Thank you. Yes, Mr. Stevens.
Thank you, my Lord. I did hand my head up to the court yesterday, my Lord. I've substituted it. There was one or two spelling mistakes, and I've also added an index to it, my Lord. So it's the same heads, but just with a few small alterations as to spelling mistakes, etc., my Lord.
Yes.
My Lord, after the finding in the first inquest, there was major disquiet. And I must start like I start with my opening address, my Lord. I must refer ironically to the very quote from the decided case of Timol versus the Magistrate of Johannesburg. Nevertheless, the inquest must be so thorough that the public and the interested parties are satisfied that there has been a full and a fair investigation into the circumstances of the death. My Lord, now we can say the audi alteram partem rule has been complied with. We have given the detainees a voice, my Lord. So both sides have been heard now. You've got the benefit now of more than 1,000 extra pages. So while you rely on the old inquest, you've got an extra new evidence that you can rely, and that we can say that it was a full and a fair investigation, my Lord. My Lord, this is a reopened inquest in terms of Section 70A. It's unique. In other words, after the determination of the original inquest, it was deemed necessary and in the interest of justice that a judge of the Supreme Court should reopen this inquest. And I want to emphasize the word, in the interest of justice. This is what it's all about. It's to set the record straight, my Lord. It's the interest of justice. It's not an appeal or it's not a review. It's in the interest of justice, my Lord. Such a reopened inquest should, as far as possible, my Lord, be continued and disposed of on the existing record of the proceedings. And Section 72 of the Act also apply. As to this court's powers, the prosecution will address you a little bit later on in regard to the findings that you will make, my Lord. But in generally, we've taken further evidence as the Act prescribed. But to a certain extent, the original record is still very important, my Lord. You've got to have the original record, and for instance, if you take the post-mortem, we've got very good evidence of the two forensic pathologists now, but they rely on the original inquest, my Lord, and that's just as the Act prescribed. There can be no question, my Lord, that the voice of the detainees were not heard before in this closed circuit and this closed system that we had, my Lord, like Professor Don Foster described it. So it was in the interest of justice that everybody should be heard. But you've also got the benefit now of the forensic pathologist, Dr. Holland and Dr. Naidu, that analyzed the original inquest, my Lord, and they are of appreciable help. And similarly, we've got the aeronautical engineer now, Mr. Mothle, that can help you a lot. And that's important, my Lord. And I want to quote from the original inquest because it's so interesting. Brigadier Patel, testifying on the 7th day of the original inquest, he answered some of the questions from the presiding magistrate, Mr. J.J. de Villiers. He said the following, my Lord. Had Sergeant Rodriguez pushed the deceased dead or alive from the window, the body would have fallen perpendicular and landed in a cement moat much closer to the wall. He testified that he measured that Mr. Timol had hit the ground 3 meters away from the building. The body being where it was indicated to me that a certain amount of propulsion had propelled Mr. Timol away from the building. He told the court that from the 10th floor there was a sheer drop with no projections which the body would have struck on the way down, causing it to be propelled forward. Mr. E.C. Meisel's Queen Counsel, QC, my Lord, for the Timol family, asked Brigadier Patel if he had done any experiments regarding falling objects. So Brigadier Patel answered, "No, sir, I've left that to Isaac Newton. I only know what I have read." Now, my Lord, that's actually more tragic than it's comic. That's exactly the reason why we had to reopen this inquest, why we needed the expertise of Mr. Mothle, of an aeronautical engineer. It's very easy for the layman to misunderstand the trajectory of a body. And that's exactly why it was in the interest of justice. And that's why I took that quote, my lord. So on the one hand, you've got to rely on the original inquest, but on the other hand, my lord, you've got to analyze that inquest very meticulously to see if the interest of justice, you shouldn't change some findings.
The difficulty, Mr. Pretorius, is that as you are aware, 652 pages of the original inquest proceedings are missing. And those have to do with the examination of the police who testified. And I found it strange that only the evidence relating to the police should disappear. Now, I'm unable to make an assessment as to what their performance was in court because of the disappearance of those. How do I deal with that situation?
It's quite a shortcoming that we do have, my lord, but to a big extent, we still have the affidavits. All the affidavits is available. And I must say, the original inquest court did sum up all the police's evidence. Yes. So we've got a complete summing up of the evidence in the original inquest, my lord. There's one or two things in cross-examination, obviously, that's not there. Yes. But for the most important one, we also had Mr. Rodriguez here, so you could observe Mr. Rodriguez while giving that. So the crucial witnesses, my lord, is still very important. And if you take Brigadier Patel, for instance, even the inquest court finds that Patel, he did not collude with General Buys, etc. So he found him to be a very, very credible witness. And to a big extent, it's Brigadier Patel that brings out the biggest contradictions with Rodriguez's evidence. It's him that has taken that photographs and insisted that Peter van der Merwe, the photographer, come back that very same night. So, yes, my lord, there's shortcomings, but I still say we've got the affidavits and we've got a total summing up of the evidence in the judgment of the first magistrate. Yes. And I don't think that's too big a shortcoming, my lord. Yes. Thank you, my lord. If I can do a summary of the submissions to the court, why I think it's the interest of justice and why your findings should differ from the original finding. In accordance with Section 17A 3B of the Inquest Act, it stated that you, my lord, shall record any finding that differs from the finding referred to in Section 16.2, as well as in the respect in which it differs. And my lord, there's a few themes. I know you've got to answer just 4 questions, and I think just 2 of them is in contention. The others, as to the identity and the date on which Mr. Timol died, there can be, it would be common cause. It's just the other 2. But there are certain themes that I think that you should need address. In the original inquest, my lord, there was a main finding that there was no assault on Mr. Ahmed Timol. And my respectful submission to you is that is wrong. That should be changed. It is said hy is nie aangerand nie en geen rede om al die getuienis te verwerp nie dat Timol op 'n beskaafde en 'n menslike wyse behandel is. That, my lord, is wrong. And in the interest of justice, it must be rectified. There was a finding that there was no torture, my lord. And closely related to that was whether Ahmed Timol was involved in a brawl. Now, firstly, my lord, we've got the evidence of Dr. Salim Esop here that vividly described how he was brutalized. And that's been said quite often in this court. If that happened to him, what would have happened to the bigger fish in this? We've got the evidence of Dr. Dilshad Jetten and Dr. Knight so poignantly saying about Van Tonder that was kind to him, and he only remembered that kindness, my lord. Now, all this confirms assaults and torture on the detainees, my lord. There can be no question that they were assaulted.
Significantly, the police witnesses only dealt with assault. They denied that there was any assault or any assault that they witnessed. But they didn't touch the broader subject of torture. In fact, Els, who testified, conceded that by making a detainee stand the whole night being under interrogation, that is a technique that they apply, which is a form of torture. It may not be an assault that results in physical harm that we see, but it's a form of torture. And one has to look at those, including electrocution, which obviously the doctors may not have been able to pick up from the body. But then one has to look at the concept of torture broadly and not confine it to assaults only. And I want you to deal with that, to comment on that.
Yes.
That the evidence as it stands now, does it allow me to make a finding that one, all the detainees were tortured, and two, that some, if not all of them, were assaulted, and three, that the interrogators are the people who were responsible for them?
With respect, quite, my lord, it's just like this court has put it. If we take the evidence of Professor Don Foster, and he described it quite well, that it's not just physical assault that should be taken into account, but it's psychological also,
Yes.
Being arrested. He describes the background and the scientific approach to torture quite well, my lord, if you take his evidence.
Yes.
And quite rightly, and I've put it in my head, that we got unexpected assistance in regard to this point of torture from Els. He said, yes, it was acceptable. You try to break the man as quickly as possible with sleep deprivation. It's acceptable. And that in itself, my lord, is torture. So this court can make that finding
Yes.
in regard to that, my lord.
Okay.
Also very interesting, Dr. Dilshad Jetum, that said, well, they immediately took away a watch.
Yes.
So to disorientate it. And very interesting here also is Professor Nike, how they did the specific torture that would leave no marks if they used cloth to put that and hang you on the broomstick, my lord. And it doesn't leave any specific marks, just your hands is the one. And there can be no question that he was tortured in that fashion.
Yes.
I mean, we get it in his file. Physiotherapists came to see him for 3 weeks. He had to, so there can be no question that he was tortured in that regard. And also very interesting, my lord, it's not just the question of torture for Dr. Salim Ensel, it's also how. Hanging him over the stairs, my lord.
Yes.
And then how to cover it up. If we look at Professor Nike's evidence specifically, all of them said, yes, he stood like that. So the cover-up was quite clear in that one, my lord, how they covered it up to say, well, everywhere, whether he sit or stand, he stood like this. So you couldn't see his hands, my lord. So everybody in their statements covered up like that. So
Yes.
it's a number of matters that you've got to take into consideration. And yes, we also get the evidence of Elsa that helps us about torture, my lord. If we combine it, all the strands then is pulled together by Don Foster, where he did his scientific research and said on a systematic basis. And it's quite interesting, my lord. He has done this research 35 years ago, and it related to the 70s and to the 80s. And he pulled all that strands together of the similar facts, my lord.
Yes.
And then we add all the Erasmus evidence.
Yes.
So if we got the medical evidence, the evidence of the detainees themselves, Paul Erasmus, Don Foster, the totality of evidence, my respectful submission to this court is that you can make a finding of torture, firstly, my lord. And secondly, if you take the injuries on the body of Ahmed Timol, you can make a finding of assault on Ahmed Timol, my lord. So I say that's the starting point. The first finding that differs from that court would be he was assaulted. Ahmed Timol was assaulted, my lord, on the totality of evidence.
So in other words, from the missing documentation, there wouldn't be any evidence that shows that he was injured in a brawl somewhere, because that's what the magistrate found. He attributed the injuries as having been sustained in a brawl before his arrest.
Exactly, my lord, and that's why the evidence of a person like Dr. Salim Esop was so important to say, this is the kind of person that Ahmed Timol was. He was a kindly type of person that didn't go around and got involved in brawls. My lord, on the probabilities you can find that he would not have become involved in a brawl. And we've got direct evidence to that, my lord, also on the affidavits. People that have seen Ahmed Timol on that Friday afternoon, and even Dr. Salim Esop can say there was no injuries on him. And lo and behold, it's a double-edged sword also, my lord. All the witnesses from the police said, well, we didn't see that he was assaulted, but at the same time, and I'll quote it to you, it's in my head also, they also had to say, but we also didn't see any injuries on him. So it's a double-edged sword, that one, and I'll quote that to you. So, my lord, the first point I want to make is, and the first theme, is you can make a different finding in regard to assault and torture on Ahmed Timol. The second big theme and that I want to address to you is a question relating to suicide. And closely related to that theme, my lord, is the reason for suicide. Now, what I want to state there, firstly, I want to say there can be no question that this court can find that the last part of Nkululeko 2 is a falsification, and a crude one at that. You can find that, my lord. Ronnie Castle's evidence proved that last little part is a total falsification, my lord. But you can combine that evidence of him with Esop Pahart's evidence, Stephanie Kemp, but also Paul Erasmus that talked about Stratcom and how they falsified things, my lord. If you take the totality of the evidence, you can find that reason that they wanted to present to the court about the policy of the Communist Party, you can find that that is a falsification, my lord. Secondly, in regard to the same theme of suicide, my lord, I respectfully submit that this court can find that the shock on the face of Ahmed Timol when the name Quinton, Jacobson, Henry, and Martin was mentioned and that they were identified, you can also reject that version, my lord.
Before we get to that version, still on this publication of Nkululeko 2, towards the end it says issued by the Communist Party of South Africa. And we know that at that time that organization had been dissolved. It had been banned, in fact, and faced in terms of Section 50 of the Suppression of Communism Act. And thereafter, it was dissolved. And at the time of this particular publication, there was in existence the South African Communist Party, and not Communist Party of South Africa. Could the magistrate have seen that difference?
I'm not sure whether the magistrate would have picked that up if there was not evidence to that effect, my lord. I'm not sure whether everybody would have been au fait with the smaller details, the nuances,
yes,
that people that are well acquainted with it would know. I don't know whether you should see it, but now it's quite obvious that it's a big,
yes,
it's like Afrikaner like me trying to make the language mistakes that we find in that last part, my lord.
But then the other obvious glaring problem with that document is that it is dated February 1972, about 4 or 5 months after Timol had passed on. If it was produced in February 1972, how could the magistrate not have seen that this document is dated February 1972, and Mr. Timol died in 1971, and therefore how could it have been a reason for him to commit? I just couldn't understand the reasoning there.
It's quite right, my lord. Once again, this court hits the nail on the head there, my lord. That's quite right there. Maybe we can find a reason, if we've got to find a reason for that, is because only a small part of that publication was quoted to the court. It wasn't necessarily handed in. That just part was quoted about suicide, was quoted to him, and then that's possibly the reason. And it was only in the Neil Agate that it was used, my lord. So I'm not sure that the whole document was handed in.
Yes, Mr. Bezos said that to his recollection, it wasn't handed in the evidence. But he said, I came to be in possession of it. Yeah. In his judgment, the magistrate says, I came to be in possession of it. How, he doesn't explain. From whom, he doesn't explain. And these are some of the problems that I have with his conclusion on that document. But I take note of what you're saying, so you may proceed with the other.
Thank you, my lord. So I say this court with big confidence can find that is a total falsification, my lord. The second one of this theme of suicide is that all of a sudden, all three of the gentlemen in that room could see shock on the face of Ahmed Timol when Quinton, Jacobson, Martin and Henry's name was mentioned. That you can also reject, my lord, as a cover-up and as a sham. The evidence of Advocate George Bezos, as well as Salim Esop and a number of other witnesses, proved directly that there was no political link between Quinton Jacobson and Ahmed Timol. My Lord, so there was no reason that there should be a shock. I'm not even talking about the improbability of seeing this, the shock from the top there. But once again, it's like the folding arms cover up, my Lord, where all three of them say the same thing and say, look shocked when that happened. And this is also where Paul Erasmus's evidence come in. Obviously, he would have been questioned about Quinton, Martin, and Henry to see if they were politically involved. And like Stratcom, they've got to base it on something realistic. So that's the reason why they would bring in that comment. I'm submitting to this court that you can find that that's another cover-up by the police. All three mention it in their statements, my Lord, and it's a cover-up. And the further one about suicide also is, once again, all three of them mention, according to their opinion, the long term of imprisonment would have been another motive why he committed suicide. Now, firstly, that is inadmissible opinion evidence of a policeman. If I have called Don Foster or Diane Chandler or a psychologist, then they can venture an opinion like that. But once again, the long-term imprisonment would not have been a motive, my Lord. The bottom line is that you can reject the finding relating to suicide. That's the submission that I make to this court, my Lord. So, and my learned junior also said the evidence of SABC was very important here as to the cultural taboo of this type of thing, my Lord. So in regard to suicide, this court can make a finding that the well-prepared type version of the security police, including the opinion about the long-term imprisonment and the shock about Quinton Jacobson, you can reject that version, my Lord, and say that this was a cover-up and that it was not suicide. My Lord, I also show in my heads that there are a myriad of unsatisfactory aspects in the evidence of Rodriguez. There are serious contradictions in his version, as well as major improbabilities. Some of the major contradictions were noted by the original inquest. Wesenlike verskille, it was said there, spelling mistake also in regard to that. But the original inquest court found that to just show that there was no collusion between Patel and General Buys. My Lord, with respect, that's not the correct approach. We must still explain the big contradictions. It's good to tell me, well, the fact that Patel knew that his evidence is going to be different from Buys show that there was no collusion doesn't explain why Rodriguez is telling 5 different stories about what happened in that room, my Lord. So, with respect, the original inquest court did not address the material discrepancies and the major improbabilities in that version. And in that regard, your findings should also be different. My Lord, in a closed system like Professor Don Foster would have described it, by and large, all the decisions in the original inquest was in favor of the security police. The conversation, for instance, by Ahmed Timol, where she talked about the pak sla and that they shouldn't give Timol a pak sla, my Lord, that had a ring of truth to it, and she was corroborated by her husband. In the interest of justice, those type of findings should be corrected by this court, my Lord. So to summarize the main themes that I want to address to this court, first and foremost, the finding that there was no assaults and no torture. That is wrong, my Lord. The combined effect of all the detainees' evidence, with the medical evidence, with the evidence of Professor Foster and Paul Erasmus, Elsa's evidence, as well as the file of Van Niekerk, my Lord, on the totality of the evidence, you can find that there would have been assault and there was torture. Secondly, the finding about suicide is wrong, my Lord. You can find that the last part of Nkululeko 2 is a falsification. The evidence of Ronnie Castles, Paul Erasmus, and all the other members like Dr. Salim Esopart and Stephanie Kemp, that is proof of that, my Lord. There was a cover-up by the police to say there was a shocked expression on his face about Quinton, Martin, and Henry, my Lord. You can also reject that. And if we move from there, then we'll get to your findings in the end. My Lord, if you look at my index to my head, you'll see from page 7, there's an analysis of all the detainees' evidence.
Yes.
Dr. Aesop's evidence is discussed there from 7 to 13, Professor Nike. I might just make an addition to Dr. Aesop's evidence that he's also important in regard that there was no political link between Quentin Jacobson and Ahmed Timol, my lord. That's just possibly the one. But all the evidence is discussed there. Also, the relevant case law is set out by my learned junior quite brilliantly, my lord. And then we also find the analysis of the medical evidence in the original inquest. That I'm not going to read through all that and repeat what you've heard, my lord. Maybe if I could jump to the basic version by the security police, and if I can concentrate possibly on the analysis of the Rodriguez version, and that's more or less on page 67 of my heads, my lord.
Yes.
67, my lord.
Yes.
If the court could just bide with me. I'm not going to go into the version of the security police in general about the shock on their face. I've just addressed that matter to this court, my lord, that is a sham and a cover-up, a falsification to get a reason why he allegedly committed suicide. Maybe before I just start with the Rodriguez version, I can take the preconceived conclusion by the independent police investigation there on my page, man. From the beginning, I state there, my heads, Lord, the preconceived conclusion was made that no foul play was suspected in this regard. If you compare the typed investigation diary, my lord, you'll find it very early on that it stated there, daar's geen rede om enige gemeenspel te vermoed nie. Even in the report, we get that very early on, that one newspaper clipping that said there's no gemeenspel, no foul play. My lord, that approach with respect is not the correct one that you can make so early during that. As to Rodriguez's version, a major proportion of what happened in room 1026 is provided by João Rodriguez. And basically the version of the security police in this regard is that Ahmed Timol was being questioned again by Captains Gloy and Van Niekerk on Wednesday the 27th of October. At more or less 3:30 that afternoon, Rodriguez arrived with salary checks and an envelope with a document in it, my lord. He also brought in 3 cups of coffee, according to him. Now, he just stood there at the end of the table and he did not take part in the interrogation. A mysterious person, Mr. X, entered and mentioned that the person, Quentin Jacobson, Martin and Henry, were apparently identified or arrested, according to his version. And then, this was according to all 3 policemen in the room, that gave rise to shock on the face of the detainee. Captains Gloy and Van Niekerk left the room to discuss the matter on the 9th floor, and Gloy asked Rodriguez to look after the detainee. The detainee asked to go to the toilet, and when Rodriguez was sitting at chair A, where Captain Gloy was sitting previously, the detainee moved, bolted around the table, or rather stormed around the table, and he left through the window. Exactly how is not stated. Now, my lord, there are a number of unsatisfactory aspects to this version, as well as major improbabilities and contradictions. If I can just quickly run through them, my lord. Whereas his real name is João Anastasio Rodriguez, he gives evidence under the name of Jan. And I quote there, your clerk asked him, "U volle naam en van asseblief?" Witness, Jan Rodriguez. He's confronted with this on page 685, line 10 to 20. So your real name is João Anastasio. So my actual name is João Anastasio. I put it to him, you did not try to get away from the past, did you? He did not understand it from my past. He said, yeah, I do not understand the question. But then, my lord, in the end, when you questioned him about the commendation by the Commissioner of Police that has written the letter for him, and that he was not even interested about it, he once again said, it's iets van die verlede, something of the past, my lord. He also viewed the country as being in a war situation, and he wanted to get trained from the very experienced persons who were at the border. Ek het een keer teruggegaan, dit was nou na die polisie toe, that I said in brackets, want ons was in 'n oorlogssituasie en ek wou die opleiding kursus wat die polisie aangebied het vir die manne wat grens toe gaan, wou ek deurgaan. Dit was net 'n tydelike storie vir my. Ek het toe die opleiding gekry en is terug na die werk toe waar ek was. In cross-examination, he was confronted with this. My lord, obviously he has been less than honored when he wanted to re-enroll in the police in this case. The approach of this witness that he only heard about torture in the security police, but he has never seen it. The court also asked him about this approach, my lord. And then if you go through his file, you'll find a number of references that he is a sub-redacteur. I quote them, my lord, all the references in his file relating to him being a sub-redacteur, and I'll just read the last sentence. Tot in hierdie hoedanigheid as sub-redacteur is dit reg. Yet, when I asked him, then he was inderdaad 'n redakteur, 'n sub-redakteur by Hoofstad, he said, nee. He was asked specifically, evidence-in-chief, whether he had undergone specialized training, my lord, and his emphatic answer was no. I quote his evidence. Did you do any other specialized police courses during your service? Geen. He states later that hy geen bykomende kursus geloop het in die polisie nie. It's later on it's quite shown that he did this teen-insurgency, this counterinsurgency training, and once again, if we look into his file, it's stated there under the heading, kursusse in 1976, June 12, teen-insurgency. Once again, his evidence about this umbrella term for counter-insurgency is not satisfactory, my lord. He was asked about this, and an umbrella term for this, could it not perhaps be counter-insurgency training? I cannot say that. And then the court quite correctly asked him, but you cannot dispute that either. His evidence now is that Quentin Jacobson was arrested, not identified. And once again, my lord, I quote that. Then I come to the improvisation where he wasn't introduced to Ahmed Timol. It was a big need-to-know principle that was there at the security police. He didn't know what Hans Gloy, Captain Gloy, and Van Niekerk did. He was viewed as an outsider, and he just stood at the table. Yet, after Timol got out of the window, he knew to run out and to say, well, Timol jumped. My lord, his evidence in this regard was also totally unsatisfactory. All of a sudden, he was introduced to Timol now when he came in, and he made the addition that he was a valuable witness when he gave evidence about that. And there on page 72, you'll see, I quote, his totally unsatisfactory evidence that he gave around about this whole thing being introduced to Timol. And the other thing is, my lord, you also know quite well what's the difference between spring and duik. Why res gesta, you would have said Timol het gespring, where his evidence is actually that he dived, is also not explained. Shortly put, my lord, unsatisfactory evidence about Ahmed Timol there. The 3 cups of coffee, I'm not going to go through all this, my lord. On page 73, we'll get to the massive improbability that him being a big man, sitting in front of the window, and yet this detainee that has been in detention from Friday, in all probability, for sure he did not sleep on the Friday night, there would have been sleep deprivation, there would have been assault, yet this smallish built detainee gets around him without him touching that. My lord, that's a very big improbability. I'm not going to go too long into that, but that's a very big improbability. And as the court asked him there, he came on the eastern side, he came on the left side of the table, he went to go and sit on chair A. The court asked him, how would you have known that he wouldn't move that way? Once again, he couldn't answer that, my lord, when you ask him in regard to that. So that's a massive improbability, my lord. And his evidence that the photographer asked him to go and stand there and he's shown that out, it's totally not the truth, my lord. I state here on page 74 that it's totally improbable from where he was standing that he could see shock on the face of Ahmed Timol. He did not know Ahmed Timol from a bar of soap. He did not take part in the questioning, etc. How he would have known that Timol looked shocked at that stage. Whereas later on he said, hy drukking loos. expressionless, he looked there. My Lord, there's a lot. There's serious fundamental contradictions in his version, my Lord. There are serious fundamental contradictions between his evidence and Gloy's evidence, between his evidence and Van Niekerk's evidence, between his evidence and General Buys's evidence, and then the big one, between his evidence and General Patel. There's at least 4 big, serious discrepancies there, my Lord. On the one time he goes left around the table, on the other time the person is running towards the door and he comes back. My Lord, there's just no consistency in the version that he provides. I quote all that serious contradictions, my Lord, in regard to Gloy, in regard to Van Niekerk. You'll see that in page 76, the version of Buys. And it's only him that could have given that version to Buys. Nobody else could have given that one. And then the serious one was Brigadier Patel. And there's no explanation for the one of Patel, my Lord, because the photographer has taken pictures of him. And we've seen that specific picture where he stands to the left side of that table. And he can't explain why he's on that left side. That's the version that is given to Patel. So he wants to say that they did not make any notes, etc. They relied on the mind specifically to remember all this. My Lord, really, his version as to why there's this big discrepancies with respect doesn't go up. On page 78, I get to his most recent version, the one that he provided with. Here he said, ek het my balans verloor en ek het op die grond toe getuimel. Ek het met my bolyf op die grond beland, op die vloer beland, en toe ek opstaan, when I jumped up, I realized that Timol was not there anymore. In cross-examination, he once again said, I fell off my chair and fell on the ground. So you were on all fours. That is correct. That, my Lord, now is the 5th version about exactly what happens there. Once again, he stretched out. My Lord, regarding this new addition to his evidence that the senior officers intimidated him and wanted to make an addition to his evidence about the wrestling with Ahmed Timol in there, with respect, that's also a new addition. And quite rightly, the court asked him, but you've 27 years, why didn't you come forward with this earlier? So my Lord, once again, there's a lot of unsatisfactory aspects to it and big, fundamental contradictions. I refer to the choice of word that he himself described this as an accident, whereas his senior officers want him to add stuff to make additions. He said, daarom het ek nie verwys nie, so he withhold evidence. And I come to the point that something really terrible must have happened in that room, and he does not want to play open cards with this court, and he's fabricating, my Lord. You can reject his version. The long and short of it, my Lord, is you can reject his version as to what happened in that room.
On his own merits.
On his own merits, my Lord.
But then if one has to go into the evidence of Mr. Tokan, Mr. Adam, those who testified that the incident that they witnessed occurred in the morning, and Rodriguez is adamant that it occurred in the afternoon. Now, I have to deal with it. If I accept the evidence that what they saw was in the morning, then it casts a shadow over what Rodriguez was saying. And if I have to reject the evidence of the 2 gentlemen, together with that of the retired advocate, Matisse, who said he couldn't remember, but if we had to take a guess, it must have been in the morning because he was preparing for a case. Now, if I reject that evidence, what would be the grounds to do so? What would be the reason to do so?
Yes,
and
yes,
decide that it was in the afternoon.
Yes, my Lord. If 3 witnesses, independent witnesses, come with that kind of thing, and to a big extent it can show to what lengths that the security police can go to cover up their tracks. The difficult one for me in that regard is the evidence of the ordinary police, like Brigadier Patel and the photographer, would also come into the fore. But if that happened in the morning and they only disclose it to the other police in the afternoon, that would describe it. But then it was just a bigger cover-up. And Rodriguez was part of that cover-up.
Yes.
It's like the same where there was shock on the face about Quentin Jacobson. it just make the cover-up so much bigger.
Yes, well, the other witnesses that came in the afternoon would probably, they did not indicate that they were there throughout the day. If it happened in the morning, Brigadier Patel came late in the afternoon to take photographs. And Dr. Kemp was called in around 4 o'clock.
Yes.
But now in declaring Timol dead, he did not put in the time of death. He just declared him dead at that time.
Yeah.
He could have died earlier.
Yeah.
And which is one issue that I'm grappling with.
Yeah, it's quite difficult to think that the photographer would also be part of such a big conspiracy,
Yes.
my lord. But I mean, they needn't be part of the bigger conspiracy if they only told in the afternoon what happened, my lord.
Yes.
Yes, Dr. Kemp just also said, I passed to it. It was always interesting to me when it was not an issue that he put at the back of it, he recently died. I passed to it. It was also interesting to me why that was added.
Yes,
to
I
that
saw,
death
I saw his
certificate.
report. The report in the postmortem, it doesn't really have any detail to work from
Yes,
in terms of fixing the time of death.
yes, my lord.
And that's the difficulty. And past due doesn't mean anything. Past could have been same day as one of the witnesses
Yeah.
testified.
Dr. Naidu said that, my lord.
Yes.
So Dr. Naidu gave expert evidence on that
Yes.
specifically, my lord. So yes, my lord. But in the end, whether it happened in the morning or in the afternoon, still the last people that was with Ahmed Timol was Rodriguez. That's the last people, my lord.
If I take his version, if I reject his version, in terms of the schedule of interrogation, when Timol died, he was in the hands of Gloy and Van Niekerk. I don't think there's a dispute on that one. And for some reason, they conveniently disappeared when, at the time, they fixed that he fell out of the window. Now, he was in their care. At the very least, he was in their care. And whether they were responsible to push him out, as Mr. Mothle said, in terms of the trajectory, or not, and as to who did that, we do not have that evidence. But the very least is that he was in custody, he was in their care. And I think they owed the court an explanation as to what measures did they take to ensure that no harm is brought to him. He was in their care. He was in the care of the police. And at the very least, if a detainee is in care of the police should be held responsible for what happens to that detainee. Just as basic as that. And I'm surprised that the magistrate didn't interrogate it.
Quite, my lord. And it's in my head, it's just like you've put it now. They were responsible for the well-being of Ahmed Timol, my lord.
Yes.
And those people. So, yes, that's a narrow scope of what you've got to decide. And I quote to you, my lord, specifically there, Section 16 of the Inquest Act, Section 16.2 of the Inquest Act, that you must find as to the identity, the cause or likely cause of death, the date of death, and as whether the death was brought about by any act. Now, obviously, in terms of subsection A, there can be no question. It's common cause. The original finding was Ahmed S. op Timol, Asiatische manlike persoon, 29 jaar oud, gebore Suid-Afrikaner, onderwyser van beroep. My lord, this court can just merely find that the identity of the deceased is Ahmed S. op Timol, a South African. As to the cause or likely cause of death, it was found originally, my lord, that die oorledene is dood as gevolg van erge breinbeskadiging en bloedverlies, opgedoen toe hy by die venster uitgespring het van kamer 1026, de John Foster Plain, en geval het tot op die grond aan die suidekant van die gebou. Hy het selfmoord gepleeg. With respect, my lord, this finding, your finding must differ from this finding, and you must note in which respect you differ.
Yes.
Initially, Dr. Skeepers gave the cause of death as multiple injuries, veelvuldige beserings. Under close questioning, he said the immediate cause of death was serious brain damage and loss of blood. My respectful submission to you would be, my lord, is that you follow Dr. Naidu's recommendation where in paragraph 41 of his affidavit he states that the death was caused by massive head, in brackets brain and chest injury, vital center damage and compromised respiration. In his opinion, the loss of blood within and outside the body was not significant to any degree. Obviously, the finding regarding to suicide, you should reject that and scrap that, my lord. As to subparagraph C, the date, it's the 27th of October, my lord. We can debate as to the exact time, whether it was in the morning or in the afternoon. In the end, the police were responsible for him. And as to subparagraph D, as to whether the death was brought about by any act or omission prima facie involving or amounting to an offence on the part of any person, the respectful submission is yes. And I state here in my head, he was in police custody and the police was responsible for his well-being, my lord. He died at the hands of the security police, and their act or omission prima facie constitute murder, be it dolus eventualis or otherwise. João Rodrigues perpetuated the cover-up, for instance, that Timol looked shocked when he heard that Quentin Jacobson and 2 others were identified. There's no way that João Rodrigues, that this person could not have seen the injuries, my lord. He did not want to play open cards with this court, and his act and omission prima facie amount to an offence on the part of João Rodrigues, be it accessory after the fact or as a co-conspirator, but amounting to an offence, my lord. Thus, the security police is responsible for Ahmed Timol's death, my lord. He was meant to be held at the cells at John Foster Plain. At least there would have been checks and balances. They chose to hold him in the offices to cover up their assaults and torture, my lord. And with respect, this finding of you must be referred to the National Prosecuting Authority. I thank you, my lord.
Thank you very much. Mr. Vani, we have a few minutes before we adjourn.
My lord, would you like to take the tea adjournment, or shall I start?
I'm prepared to, but it's just a few minutes left.
A few minutes, okay.
Yes. You could perhaps give us the outline of your presentation.
Yes. And my lord, before I commence, for the record, we have passed on certain exhibits over the last few days.
Yes.
My lord, they're already in your possession, so I'm not going to hand them up, but perhaps for the record, I can just take you through those particular exhibits.
Yes.
My lord, starting with exhibit C10A, that is a 2-page supplementary trajectory report put together by Mr. T. Mothle. My lord, it deals with 2 scenarios. One, the scenario raised in the book of Gordon Winter, Inside Boss. There is a passage in that book dealing with Timol allegedly being held out the window by his ankles and then dropped. So Mr. Mothle looks at that particular scenario, and then Mr. Mothle also looks at certain of the allegations made by Mr. Rodrigues in his oral evidence in relation to the alleged dive. My lord, the next exhibit is H21. That is the affidavit of Alwyn Musson. My lord, in this affidavit, Mr. Musson contradicts the claims made by Seth Sons, who said that he never assaulted anybody. And in fact, my lord, in all these affidavits that we have filed, there are allegations and assertions that they were abused and or assaulted and or tortured by Mr. Seth Sons while in police custody in John Foster Square, my lord. So the next one is H22, that's the affidavit of Mr. Hanif Vali. The next one is H23, that's the affidavit of Mr. Prem Naidu. There's H24, the affidavit of Mr. Ishmael Momonyat. H25, the affidavit of Kevin Martin. And the last affidavit, H26, which is the affidavit of Rashid Vali Musa. My lord, the final exhibit is T, and that is the chronology that we circulated
Yes.
on Monday.
So the last affidavits you referred to, all of them deal with the evidence of Mr. Sons.
That is correct.
And they contradict Sons about his ignorance of assaults.
His ignorance of assault, the claim that he himself never assaulted anybody,
Yes.
and the further claim that he was never present during assault or torture. All those claims are contradicted.
That was his initial response, but when you questioned him, he suddenly lost memory, that he couldn't remember. He didn't totally say, I didn't assault anybody. He said, I cannot remember. When you mentioned the names of the people whose evidence you are going to lead. That's what my notes tell me.
Yes, my recollection is that that is the case, that he certainly couldn't remember names of individuals that we put to him. Although my recollection is, but we'll have to double check the record, is that he persisted with his denial of being present during an assault or him personally assaulting anybody.
Well, all three of them are saying they read about it in the papers, about the assaults of detainees in the papers. Rodriguez, Els, as well as Sons.
That is correct.
Yes.
They only read it about it in the press, and they will have us believe that they did not even discuss it amongst themselves. That's my recollection of the evidence, Your Lordship.
Yes.
Your Lordship, we have styled our heads as short heads of argument.
Yes.
We did provide you with a skeletal outline, and these short heads of approximately 40 pages add some meat and flesh to the skeletal outline.
Yes.
My Lord, we will be providing you with what we are styling as main heads of argument, and I will indicate to the court what's in those main heads. But to be clear, my Lord, we are not presenting those main heads today because there simply isn't time for that. My Lord, the story of Ahmed Timol's brutal death at the hands of members of the notorious security branch didn't begin with an impromptu roadblock in Field Street, Coronationville, on the night of 22nd October 1971. Its roots really can be traced to the apartheid system itself and its pathological obsession with race. Lord, that system didn't tolerate any serious dissent. In fact, it crushed those who stood up to it. And there were many who stood up to this pernicious system, and they did so notwithstanding considerable risk to themselves. And one of them was Ahmed Timol. He stood up to this formidable machinery, and to many at the time, that machinery must have come across as all-powerful and invincible. My Lord, the stormtroopers of the apartheid state was the hated security branch. This organization acted under the instruction and blessing of their political overlords at the time, and they targeted individuals like Timol, who questioned the legitimacy of the entire system. The security branch didn't hesitate to brutalize and, when necessary, to murder in an attempt to stem the tide of freedom. My Lord, some 21 detainees died in security detention before Timol died, and by the time of the demise of apartheid, that figure would climb to some 89 individuals. 8 of them perished in John Vorster Square, 33 were alleged suicides, and 6 involved falls from buildings or downstairs. Ahmed Timol would pay the ultimate price for standing up to apartheid. In so doing, he joined the illustrious ranks of Steve Biko, Griffiths and Victoria Mchenge, Neil Agate, Babla Saluji, Fabian and Florence Ribeiro, and many others. Lord, these names will be forever remembered and cherished by South Africans, but the names of their tormentors will live on, but only in ignominy. The story is also a story of great injustice. It's a story of how dark forces were able to cover up crimes of torture and murder for some 46 years. It's the story of unbridled brutality meted out to young men and women held on the 10th floor of John Vorster Square. It's the story of ugly collusion between police officers who were meant to uphold law and order, but instead who covered up crimes of torture and murder. It's the story of a magistrate, Magistrate J.J.L. de Villiers, his assessor, Professor I.W. Simpson, and a senior public prosecutor, 1 P.A.J. Kotze. My Lord, Mr. Kotze appeared on a regular basis in political trials, and 10 years later, after the Timol case, he was chosen as magistrate to preside over the Neil Eggert inquest. These individuals engaged in a charade of justice, happily playing their part in suppressing the truth and providing the imprimatur of legitimacy to the murderous conduct of the police. My Lord, Mr. Imtiaz Kaji has spoken of the neglect, and I'm not going to take that matter forward. He has placed that on record. Nonetheless, it is lamentable that action couldn't have been taken while key suspects like Gloy van Niekerk and General Buys were still alive. We would submit, though, that the reopening of this inquest provides the National Prosecuting Authority with an amazing opportunity to respond to the long-standing suffering of families of apartheid-era victims in their search for answers and justice. It's also the story of great inspiration and perseverance. The Timol family, my Lord, in particular Timol's nephew and brother, Imtiaz Kaji and Mohammed Timol, they refused to let go of their quest for truth and justice. Their resolve and determination has been rewarded with this inquest before this particular court. For the first time, my Lord, in 46 years, there has been a serious investigation of Mr. Timol's demise. Every possible aspect has been investigated by this court. And my Lord, this court has permitted the family the latitude to explore the full truth, and for that they are deeply grateful. Lord, the family extended an open hand to the surviving police witnesses. They went on record to say they're only interested in the truth. They sought no vengeance or retribution. If the truth was disclosed, they would not seek a prosecution on any particular charge. Lord, regrettably, this particular plea was spurned by the police witnesses. They doggedly stuck to the hymn sheets concocted by their masters decades ago. The police version largely adopted by the inquest court really asks us to suspend our belief in reality. They will have us believe that the security branch did not carry out torture. They will have us believe that they only heard about torture through claims made in the media. They will have us believe that Timol was treated with care and compassion by the security branch, and unbelievably, just like one of their own children. My Lord, that claim was made by none other than Colonel Piet Greyling, who was the officer commanding of the security branch in John Vorster Square at the time of the Timol incident. And it emerged in the Aesop case, the interdict to have a restraining order finalized against the police. They will have us believe that Timol's interrogators were honest and fair men. They will have us believe that Timol would have preferred death to a long prison sentence. They will have us believe that they did what they could for the critically injured Timol. They will have us believe that the police carried out a rigorous and methodical investigation in reaching the conclusion that nobody was to blame. My Lord, none of it is believable. None of it bears any relationship with the truth. In the circumstances, the Timol family seeks justice against the police witnesses who continue to perpetrate the cover-up of the crimes committed against Timol.
We'll take an adjournment at this stage.
As the court pleases.
Yes, Mr. Vani.
As the court pleases. My Lord, the next section of our heads deals with the contents of the main heads, which we intend to hand up to you. I don't intend to take the court through its contents, but it will essentially comprise of summaries of the evidence and various legal considerations. My Lord, I'm going to move to page 8. And my Lord, I wish to commend the chronology, which is an exhibit, Exhibit T, and it's also Annex A to this particular heads of argument. We do so, my Lord, because it gives a bird's eye view of the entire case and much of the evidence before this court. My Lord, it allows one to connect the dots. It allows one to make connections between events and between individuals over time. And it really does place the fateful days of the last week of October 71 into its proper context. If time had permitted, I would have taken the court through certain entries in order to begin the process of connecting the dots, and perhaps if time permits, I'll still do so. But in order to finish in my allotted time, I'm going to skip that particular exercise. Lord, I'm now going to turn to the police version as to how Mr. Timol met his demise. And my Lord, the police version is effectively the finding of the first inquest court, because that court, by and large, accepted the version of the security branch. And essentially the finding of Magistrate de Villiers was that the late Ahmed Timol was not mistreated by the security branch, and the cause of his death was attributable to him taking his own life. And it rests essentially on a few factors. On the question of them not being any torture or abuse, the police version is that they never tortured or abused Mr. Timol in any way. And we've also heard from police witnesses before this court that the security branch did not torture or assault detainees. As we discussed a bit earlier, they merely read about these in the press. Indeed, according to the first inquest court, Timol was treated in a civilized and humane manner. The police suggested that they wouldn't have harmed Timol because he was regarded as a big fish, and he was of an inestimable value to the security branch. And this much was clear because apparently they knew that Timol and his followers were busy with a campaign of sabotage and even mass murder. And then finally, any pre-fall injuries reflected in the postmortem report probably explained by a brawl, and to quote the magistrate, where Timol was possibly pushed around and possibly also fell. And my Lord, on this score, I'd like to draw your attention to the evidence of three witnesses. Mr. Esop, who was with Mr. Timol on the night of the 22nd. Chotia, who visited, or rather Mr. Timol visited Chotia on the day of the 21st. And then Farouk Dindar, who visited the Timol home on the evening of the 22nd. Their evidence, my Lord, and it all set out in the chronology, together with references. Their evidence is that Timol was in good form, cheerful, and no injuries were observed by them, and that he moved about easily. My Lord, when you get to look at the chronology, that's on pages 6 and 7. My Lord, the other leg upon which the inquest court rested its conclusion that nobody was to blame was because Mr. Timol committed suicide on the strength of the following evidence. One, the evidence of a pay clerk, one Sergeant Jean Rodriguez, who claimed to have witnessed Timol diving through the window of room 1026. Then there were various speculative claims of the police. One of them was that he feared serving a long prison sentence. And there are quite a few references in the police affidavits to that apparent fear. And then, of course, as we've heard already, it was Communist Party policy or doctrine to commit suicide rather than to betray your comrades or your organization. Now, my Lord, our next head is short and sweet. It says the police version is untenable. And we would submit to you that there's little or nothing in the police version that can be accepted. We would submit that the finding of Magistrate de Villiers that Timol was not assaulted or mistreated has to be rejected. It doesn't bear the slightest resemblance to the similar fact evidence or the hard forensic medical evidence, which we'll turn to shortly. Indeed, it is our submission that the evidence of Rodriguez must be regarded as wholly unreliable. His evidence before the first inquest court, as well as this inquest court, is manifestly false. My Lord, turning to the similar fact evidence, the finding of Magistrate de Villiers was that Timol was treated in a civilized and humane manner, and that rests entirely on the say-so of the police witnesses. Lord, we would like to submit that this honourable court will have little difficulty in reaching a diametrically opposite conclusion. The Timol family have placed substantial similar facts, torture and abuse sustained by detainees at the hands of the security branch throughout the 1960s, 1970s and 1980s, and in particular by detainees held on the 9th and 10th floor of John Vorster Square between the 23rd and 27th October 1971. Lord, we're not going to go through this evidence. We have supplied a summary of the witness testimony in certain exhibits, and indeed we have attached as Annex B excerpts of experiences of assault and torture of these witnesses, and we don't intend to take you through that in our arguments. But my Lord, for the record, let's just say who these witnesses are. In relation to individuals who were detained in the same time period as Timol, there's Dr. Salim Esop, there's Dr. Dilshad Jetham, and there's Professor Kantalal Naik. Mohammed Timol was detained in the same period, but much of that detention happened down in Durban. Then in relation to individuals who sustained torture at the hands of the security branch through the 60s, 70s, and a few into the 80s, there's Stephanie Kemp, Shanti Tweedy, formerly Shanti Naidu, Snooki Zikalala, Lalu Chiba, Abdullah Jasset, Peter Magubani, the renowned photographer, Monica Dube. Turning to the last list we have, and these are individuals who contradict the claims made by Seth Sons that he was never involved in assault and never witnessed assault. It's Alwyn Musson, Hanif Vali, Prema Naidu, Ismail Mominat, Kevin Martin, and Rashid Vali Musa. Lord, perhaps the starkest example we have of similar fact evidence comes from Dr. Salim Esop's harrowing account of torture. At the time he was arrested, he was a mere 22 years old. He was a medical student. He opposed apartheid. He did what he could to stand up to that system, and that included helping to run a bursary scheme for disadvantaged black students. But on the illegal side of things, he was assisting Ahmed Timol in reproducing and distributing SACP literature. He wasn't a member of the SACP. He was not in communication with the organization. He certainly didn't know who Timol was communicating with in London. And notwithstanding his subordinate and support role, he was subject to some of the most barbaric torture ever recounted in a South African court. It was vicious, sadistic, and unrelenting. By Tuesday morning, Esop was in a comatose state and close to death. He had to be rushed to hospital, and his father had to obtain an urgent court order to restrain the brutality. Now, my Lord, the police will have us believe that Timol was never assaulted. Indeed, he was treated with care and compassion. My Lord, it's a version that would be laughable if it were not so tragic. It begs the obvious question, why would the security branch torture Esop to near death, but treat the big fish with kid gloves? It makes no sense whatsoever. And we submit that this honourable court will have little difficulty in concluding that the big fish in the form of Timol was tortured with equal, if not greater, ferocity than endured by Esop. Lord, it is absolutely no coincidence that Esop was kept locked up incommunicado while the first inquest was underway. That was part and parcel of the cover-up. If his
Right on this one, Mr. Valley. Esop, yes, was held in terms of Section 6 of the Terrorism Act. And he appeared in court in March 72. And if I remember the provisions of the Act clearly, is that once you appear in court, the section falls away. You are now an awaiting trial prisoner. You may not be on bail, but you are in custody awaiting trial. And the Act itself, in fact, specifically mentions that the detention in terms of Section 6 ends when the minister brings it to an end, or the minister does not extend periodically, as he was empowered to do, or when the person is charged in court of law. Now, from March to April, when they started with the inquest, he was still in custody. But could we say that he was under Section 6 of Terrorism Act?
Lord, that's an intriguing observation, and one I have to confess we hadn't considered. But since you've brought it to our attention, I think the point is a good one.
Yes, well, Mr. Bezos did testify that the police had built a wall basically around him, and they prohibited access to him in many respects. But then during the inquest, when it started in April, he and Amina Desai and other people had already appeared in court. And I didn't canvass this with him as to what was the conditions like after his appearance in court, because that was after the whole thing. But then it occurred to me that the magistrate could have had access to him, given the fact that even though the Terrorism Act excluded the jurisdictions of the court, but then, especially in regard to inquiring under Section 6 of Terrorism Act, but then he was already outside Terrorism Act Section 6, and therefore he was an awaiting trial prisoner. And he could have subpoenaed him, given the fact that there was this finding by the High Court, then used to call Transvaal Provincial Division, that he had been assaulted. And his case is linked to Timol in the sense that he was arrested with Timol. I've been grappling with that part of the evidence, because I have to say something about whether, if the magistrate really used the powers vested on him in terms of the Inquest Act to subpoena witnesses that may assist in determining the truth. And it looks like he was very shy in doing so, and this is one of the instances. And he cannot hide behind Section 6 of Terrorism Act, because Esop had already appeared and it had lapsed. He was held now on order of the court, because once you appear first time in court and bail is not granted, It's the court that orders your detention, and therefore he was under detention as ordered by the court. Common sense tells me that. And you said you haven't looked at it, but just look at it, and I'll be willing to accept additional submissions from your side on that aspect in particular. And Dr. Pretorius, that goes for you too. If you could just look at that aspect, perhaps I'm wrong, but my reading of the Terrorism Act, Section 6, is that it terminates when the minister says so, or when he doesn't give the extension, because it was extended periodically, at the request of the police, or when a person appears in court.
We'll do research, my lord.
Yes, if I could get your submission on that. Yes, you may proceed, Mr. Valle.
Thank you, my Lord. My Lord, we certainly will explore that point in our main heads, which we will supply to you next week.
Yes.
My Lord, if one looks at the dates that you have referred to, if I can just find that. Yes, so Salim and his co-accused appeared before the magistrate's court in Marshalltown.
Was it in March? I think it was.
No, sorry, Marshalltown, Johannesburg, at the magistrate's court.
Yes.
So it was 8th of March, 1972.
Yes. So by then, after that appearance, Section 6 had lapsed.
Yes.
So he could have been available to come and testify, even though he was in custody.
Yes, indeed.
Yes, proceed.
And several months of the inquest still had to run.
Yes.
My Lord, on that point, it occurs to me that the magistrate's court, at the very least, could have issued a subpoena, and the police could have come and said, well, we object to the subpoena on the following grounds.
Yes.
State security, whatever.
Yes.
My Lord, while we're dealing with the question of dates, we also note that the judgment of the full court in the ESOP interdict matter, so that was handed down, my Lord, on the 25th of February 1971.
Yes.
Sorry, 1972. And then some 4 months elapsed to the inquest court finding on the 22nd of June 1972. And my Lord, there isn't a whisper of that judgment in the inquest court finding. And my Lord, we would submit that the inquest court must have known about that judgment. And they should have known through the evidence that was led that Mr. Esop was detained with Mr. Timol in John Vorster Square at the very same time. My Lord, the evidence of Esop and the other detainees demonstrates that torture was routine and systematic practice of the security branch at that time. My Lord, my learned colleague, Mr. Pretorius, has already referred to the research of Professor Don Vorster, and I won't go there either. But I would also wish to refer to the experiences related to this court by George Bezos, SC, who represented numerous detainees over decades. And my Lord, we would also wish to refer you to Mr. Bezos' book, No One to Blame in Pursuit of Justice in South Africa, because that book is replete with many cases dealing with torture and assault of detainees in South Africa. Lord, we heard from a former security branch officer, Paul Erasmus, and he confirmed that quite vicious torture was meted out to detainees on the 10th floor of John Vorster Square. Lord, I'm now going to turn to the forensic medical evidence dealing with the question of torture, assault, and abuse. Before I do so, we've only had a fleeting glimpse of the heads of argument compiled by my learned friend for the police, Mr. Coetzee. And we've noticed that he relies on the PricewaterhouseCoopers case, PwC case, for an assertion that because the forensic experts that have appeared before this court, that's Dr. Holland and Dr. Naidu, because they were not present during the post-mortem, that essentially their evidence comprises speculation. That's how I understand, just with a very quick reading of my learned friend's heads of argument. Lord, the PW case, and in due course, perhaps I have it here, the PW case, and it's, I'm struggling to read this footnote. Where's the citation? We're just finding the citation for you. Or perhaps, let me read it, you find the citation. My Lord, we'll get the citation for you. But we wish to draw your attention to a holding. It reads as follows: an expert's opinion represents his reasoned conclusion based on certain facts or data, which are either common cause or established by his own evidence or that of some other competent witness. My Lord, we would say that the expert opinion that this court has heard is in fact based on certain facts and data, and that is the postmortem report compiled by Dr. Skeepers, as well as the official photographs taken of the deceased Mr. Timol. So we would then submit, my Lord, that their opinion is indeed based on certain facts and data. Lord, turning to the actual forensic medical evidence, we would submit that that evidence puts it beyond question that Timol was brutally tortured before he died. This is because the post-mortem report, the PM report, compiled by Dr. Skeepers, the senior government pathologist, sets out considerable ante-mortem or pre-fall injuries.
There are similarities in terms of the opinions ventured by the experts, except that when it comes to the extent of the seriousness of those injuries, Dr. Skeepers seemed to say these were minor injuries, whereas Dr. Holland and Naidu were saying these were very serious injuries, especially those relating to on his foot and toes which were not consistent with the fall. And one has to draw inference from that he was somewhat incapacitated to can take the kind of movements that Rodriguez described. Now, that difference, Skeepers says minor injuries, and Holland and Naidu say they were very serious. How do I cross that?
My Lord, we don't have a ready-made explanation for why Dr. Skeepers described those injuries as minor. And sadly, Dr. Skeepers is not with us today to offer an explanation. We can only turn to the best available forensic expertise at our disposal and ask them to study the post-mortem report and give us an opinion. And my Lord, we would submit that the opinion of the two experts should be favored on that particular question, minor injuries versus serious injuries. And my Lord, although it doesn't appear in my heads, and we will highlight these in the main heads, there were several shortcomings in the post-mortem report. I think both Dr. Holland and Dr. Naidu testified that it was not a model of perfection, but nonetheless it was still useful in assisting them to reach certain conclusions. My Lord, beyond that, I'm unable to offer a
Yes.
way out of that difference in opinion.
Yes.
My Lord, the two forensic experts, Dr. Shakira Holland, Dr. Steve Naidu, they studied the PM report, they studied the photographs, they both concluded that Timol must have endured sustained physical assault while in police custody prior to his death. They noted a number of injuries not consistent with a fall from height. And I'm not going to take His Lordship through all of them, but I'll just highlight some of them. There were several abrasions showing scab formation, which medically meant that they had to have happened some time back. There were bruises that were diffusely distributed all over Timol's body, and according to Dr. Holland, bruises in falls from height tend to be irregular and poorly defined, whereas the bruises that can be clearly seen in the photographs are well-defined pattern bruises. Also, according to Dr. Holland, the depressed skull fracture of the left parietal bone, my Lord might recall that was on the top of the head on the left
Yes.
side, is not consistent with the fall, because these kinds of injuries are not commonly seen in falls from height. And Dr. Naidu agreed with this conclusion, and he provided quite a good analogy, even if it is rather grim. He said that impacts at diametrically opposite sides of the head cannot occur from one fall because the body and head does not bounce upon impact such as a football, but impacts more like a sack of potatoes, which remains in the position and profile of its impact. My Lord, in oral testimony, Dr. Holland said she believed that this injury could have been caused by Timol being struck on the head with a blunt instrument, such as an iron rod or a hammer. According to Dr. Naidu, the impact from such a blow probably rendered him unconscious, and in his expert view, this could have happened at any time within 12 hours before the fall took place. Both experts agreed that this kind of depressed fracture probably rendered him unconscious, and moreover, it would have caused swelling and bleeding on the brain, and if that was left untreated, it would have resulted in death. In oral evidence, Dr. Holland said at the very least, a concussion would have occurred with possible revival, but at the very worst, it could have caused a stroke, and in some cases, paralysis. She mentioned that a person with this type of injury can slip in and out of consciousness. Turning to other injuries, the Lord will recall that there were serious fractures to the jaw. Dr. Naidu felt that the left-sided jaw fracture was not readily explained by the fall because of the recess and buttress principle. Because it was tucked in, he believed it would be unlikely to be caused by a fall and rather by a blunt force impact to that area. Dr. Holland differs somewhat, and she felt that the right upper jaw was also not consistent with the fall. But both concluded that it would have been difficult, if not impossible, for Timol to talk, eat, or drink any beverage. There's several other non-fall injuries, and again, I'm only going to highlight some of the more important ones. Dr. Holland pointed to bruising on the thigh and groin area, and she believed that this was probably caused by multiple blows to that area, such as the meal kicks, of which we've heard from Dr. Esop. And she felt that this would have impacted on his ability to move and even stand. Naidu highlighted a few injuries that were not related to the fall, that were on his lower limbs. And he concluded that these injuries are inconsistent with the fall because the patterns of injuries indicate that Timol landed on the right side of his body and not on his feet. So looking at the injuries that he highlighted, extensive bruising on the right calf. And in oral evidence, he said this was probably caused by a blunt impact, possibly an iron rod. He pointed to a dislocated left ankle. He said this type of injury usually harbors a fracture and brings into focus Salim Esop's testimony of seeing someone of Timol's stature and size being dragged along by security branch officials on the 10th floor of John Vorster Square. Naidu also looked at injuries on the toes, contusions to the toes, and he believed that this was probably caused by stamping on his bare feet. So, my lord, the medical evidence directly contradicts the police version that Timol was never assaulted or that he was treated in a civilized and humane way. And our submission is that on the basis of this evidence alone, the police version that Timol was never assaulted and that he committed suicide has to be rejected out of hand. My lord, I want to turn to some of the treatment of the evidence by Magistrate de Villiers. Now, Magistrate de Villiers had to concede that there were some anti-mortem injuries because this was disclosed in the PM report. Nonetheless, he concluded that these injuries were not caused through assault or torture during police custody. And as this court has noted, he resorted to certain conjecture to explain away the pre-fall injuries. He speculated that there might have been this brawl and Timol was pushed around and perhaps fell. However, the magistrate also accepted the evidence of the security branch that Timol was not assaulted in any way and indeed was free of visible injuries. We'll return to this point shortly, but it is something of a glaring contradiction that was never resolved in his finding. As I mentioned, he relied exclusively on the say-so of the police witnesses. And I'd like to bring to the attention of the court what he had to say of a few of those police witnesses. Indeed, he spoke in glowing terms about these individuals. As far as Colonel van Wyk was concerned, who was one of Timol's interrogators, Magistrate de Villiers wrote, "My impression is that he is honest and trustworthy, and he is corroborated by Captain Bean, another interrogator. And Bean is also honest and reliable." As far as Captain Gloy and Captain van Niekerk are concerned, the magistrate writes, "Both gave their testimony in a calm and controlled way. And I was especially impressed with Captain van Niekerk, who left me with a feeling of complete faith in his honesty and fairness. I do not have the least difficulty to accept these two witnesses as reliable and trustworthy." The magistrate really reserved special praise for these two individuals. And as it turns out, these were the two individuals who spent considerable time with Mr. Timol and who were interrogating Mr. Timol on the day of the 27th of October. So the magistrate really says, I accept the version of the police because they corroborate each other and because of their apparent calm demeanor. Now, there is evidence before this court that one of those who corroborated the evidence of another, a Sergeant Klein, according to Salim Esop, Klein was responsible for a furious assault not long before he started to assist Captain Durka in the interrogation of Timol. In relation to the views of the magistrate and van Niekerk, it's safe to assume that neither Magistrate de Villiers nor Senior Public Prosecutor Kotze conducted any background checks into van Niekerk and his colleagues. If they had, they would have discovered a veritable trove of brutality, including a conviction of 2 counts of assault in relation to van Niekerk, in which the victim died, Originally, my lord, the charge was murder. It was then reduced to culpable homicide, and eventually Van Niekerk got away with 2 counts of common assault. And the police file of Van Niekerk discloses more. As recently as 1970 and 1971, there were multiple complaints of serious assault and torture made against both Van Niekerk and Hans Gloy. And these complaints included assaulting detainees with iron rods, applying electric shocks, and all the other forms of torture in their repertoire. My lord, the magistrate was also very quick to accept the evidence of Detective Sergeants Boer and Lowe. And my lord will recall that these were the 2 individuals, security branch officers, who guarded Timol each night and claimed to have seen no injuries or marks on Timol, even though they saw him in his underpants at times.
This part of the evidence is in the judgment of the magistrate.
Yes, it is, my lord.
Okay.
And my lord, I'm turning to that judgment because somehow the magistrate had to come up with a way of resolving the fact that Boer and Lowe spent multiple hours with Timol, seeing him at times in close to a naked state, and yet they didn't see any of the injuries that might have arisen through a so-called brawl. And the breathtaking view of the magistrate is that it's difficult for laypersons to see such marks and bruising on a dark skin. My lord, not only did the magistrate accept such a nonsensical excuse, he found that while the deceased were in the custody of Boer and Lowe, they treated him well and in a civilized manner. My lord, the picture emerges of a magistrate who would find for the police, come what may, no matter what, no matter how ridiculous or glaringly false the claims of the police were. My lord, if we consider the evidence of the torture survivors, those in John Vorster Square at the same time, deprived of sleep and brutalized, if we accept that evidence, then, my lord, Boer and Lowe must have been responsible for particularly vicious crimes against Timol. As mentioned, they guarded him at night, and, my lord, this in all probability meant keeping him awake through the entire night and subjecting him to long hours of terrible abuse. We have provided evidence of the sleep deprivation and the abuse during interrogation, and we submit Timol would have been no exception. Indeed, it stands to reason, my lord, that the police would have unleashed the worst of their ferocity onto him. He would have borne the brunt of their vindictiveness. So, my lord, in all probability, on the night of Tuesday, 26 October 71, through to the morning of Wednesday, 27 October, the abuse meted out by Boer and Lowe probably rendered Timol seriously incapacitated. He probably could no longer speak and may very well have slipped into a comatose state, just as Aesop had done the previous morning. And, my lord, this submission would be entirely consistent with the evidence of Dr. Dilshad Jetham, who testified that Timol's screaming and crying stopped abruptly early Wednesday morning, then her relocation to the cells. Lord, turning to the question of suicide, we would argue that the forensic medical evidence, as well as the trajectory evidence, completely excludes the possibility of suicide as propagated by Rodriguez. We've already taken you through the forensic medical evidence of Timol's pre-fall injuries that probably rendered him unconscious. We've already spoken about the disabilities he would have had in relation to standing and moving, as well as his inability to speak, eat, or drink. And all this evidence is directly in conflict with that of Rodriguez and the police. If I can just turn to the expert evidence of Dr. Naidu on this particular question. Naidu doubts that Timol would be able to clamber up a window ledge. It would firstly have required a time interval, and if he was an injured person, considerable time. And he would probably have to use the chair or the heater panel to get up onto the window ledge. And it's worth quoting in full Dr. Naidu's summing up of Timol's ambulation ability prior to the fall in the light of his left ankle injury and right calf bruising. I quote, "Ambulation ability of the deceased before the fall, with bilateral below-knee injuries not explained by the fall being present on or in the body, the deceased would not have been able to walk normally, to get himself off the chair and to the window without being noticed and easily stopped and apprehended in the considerable time that this would have taken, and not have been able to effortlessly and without considerable difficulty and pain clamber upon a prop or ledge or chair to elevate himself up to the windowsill, nor launch himself off the sill easily." My Lord, we've also pointed to Dr. Holland's conclusion in relation to injuries to his thigh and groin, which he believed would have made moving and standing difficult for Timol.
Mr. Vani, can I just stop you for
Yes, my Lord.
1 minute? People who have come in to listen, please close your cell phones. They're disturbing the proceedings. If you want to make a cell phone, please leave the courtroom. You're disturbing the proceedings. You may proceed.
Thank you, my Lord. My Lord, the forensic evidence is at odds with the version that Rodriguez advanced on what happened in room 1026. Indeed, it rubbishes his claim that Timol moved around room 1026 with lightning speed and in a split second jumped or dived through the window. The suicide as claimed by Rodriguez simply didn't happen. My Lord, I'm not going to deal with the evidence of Rodriguez in room 1026. We will deal with it in detail in our main heads. My learned friend, Mr. Pretorius, has already addressed this court on what happened there, and we will not repeat what he has had to say. Lord, I want to turn to the trajectory evidence, because the trajectory evidence is of considerable importance. Our expert in this regard was Mr. Tivesh Mothle. He's an aeronautical engineer. He provided 2 reports that gave evidence on Mr. Timol's trajectory as he fell. In his first report, he pointed to 6 possible scenarios, and these scenarios are based on the witness statements. In his supplementary report, he considered 2 further scenarios. Now, from the outset, Mr. Mothle excluded the possibility of a dive through the window because it simply wouldn't be possible to run, open the window, and dive, at least not simultaneously. He went further in his supplementary report, saying that the specifications of the office, the arrangement of the furniture, and even assuming that the deceased had the athletic ability, he doubts very much whether such a maneuver could have been executed. Nonetheless, in his supplementary report, he says, let's consider that Timol had the physical prowess to firstly avoid Rodriguez and then engage in some form of dive out the window. And the first possibility is that he lifts himself onto the windowsill and in a standing position dives like a swimmer into the void, and that he would have been using his legs as thrust. And my Lord, Mr. Mothle says that as with a jump, using your legs as thrust off that windowsill, you would travel a considerable distance. And in the calculations of Mr. Mothle, that could be as far away as 13 meters, which would put Mr. Timol onto the road. And as we know, Mr. Timol did not land on the road. The second dive scenario is if Mr. Timol somehow clambers up onto the windowsill, leans over in a head-first fashion so that gravity would ultimately take him, and then falls head first to the ground. According to Mr. Mothle, such a scenario would not have generated much forward impulse force. And in his view, he would probably have then hit the concrete light well adjoining the bottom of the building, or at least part thereof. Now, if that had happened, then his injuries would have been considerably different, and I believe that question was put to both our expert medical doctors. Now, of the 6 scenarios set out in Mr. Mothle's first report, scenarios 1, which is a jump, and scenario 2, which is a step, and both off from something of a standing position on the edge of the window, the sill of the window, it would have been a feet-first exit, and with a jump, Timol landing at the 13 meters, as we said, and with a step at 4.5 meters. Now, what's important, Your Lordship, is the orientation that Mr. Mothle says Timol would have landed in these 2 scenarios. His head would have been in the direction of Commissioner Street. My Lord, none of the witnesses support the scenarios of 1 and 2. So the scenarios that are consistent with the statements given by the 2 security branch members, I'm now going to deal with. And the 2 security branch members are Brigadier Cecil William St. John Pattle, as well as Warrant Officer Gabriel Johannes Deisel. My Lord, Pattle stated the point of impact of the body. He put it at 10 feet, that's about 3 meters from the edge of the building. And in his affidavit, Deisel described how he found Timol's body lying in the garden. My Lord, I won't take you through that affidavit, but you'll recall that he was pointing, I don't want to make a mistake here, but he certainly wasn't pointing onto the road, he was pointing away from the road. What's important about this evidence, my Lord, is the position and orientation of the point of impact. And according to Mr. Mothle, the only way Timol could have fallen from the 10th floor and land about 3 meters away from the edge of the building and land in the Deisel orientation is if he was pushed from the 10th floor. And there are 2 scenarios, namely scenarios 3 and 4, set out in his first report. Scenario 3 is a push from the window in a sitting position, and scenario 4 is a push out the window with legs first and body facing the building. According to Mr. Deisel, those 2 scenarios have the potential to put Mr. Timol at 3 meters from the edge of the building and in the Deisel orientation. There are 2 other scenarios, and these other scenarios are consistent with the evidence of Advocate Ernest Mattis. And my Lord will recall that Mr. Mattis saw a body pass his window. He was on a lower floor. The body was parallel to the building when it fell past his window. It was facing the double-decker highway. Now, the one scenario that could explain that is scenario 5 of the first report. In this scenario, Timol is thrown from the roof of the building in a horizontal motion with his torso parallel to the face of the building. And then there's scenario 6, and that is Mr. Timol being rolled off the roof parapet. The Lord will recall that the parapet was a low-lying wall on the roof. His torso would have been parallel to the face of the building. Now, on considering the available witness evidence, my Lord, tested against the findings of Mr. Mothle, it becomes clear, and these are our submissions, that the only possible scenario for Timol's fall can be that he was pushed from room 1026 on the 10th floor in one of 2 positions. And those 2 positions are scenarios 3 and 4. I won't take you through them again.
So if you accept the evidence of retired advocate Ernest Mattis, is that when he saw the body falling, He went to the window and he looked up, he looked down, and he saw the body having landed on the shrubs. Then he looked up, and all the windows were closed. So what would that mean? Could it be that after he was thrown in as to submit, the window was closed? Or could it mean that no window was really open, he was thrown from the roof down?
Exactly, my lord, and those are our submissions. My lord, none of the scenarios described, the possible scenarios, involve suicide, and certainly they tend to directly contradict the version of Rodriguez. Indeed, we would suggest that his version is simply impossible to execute. Lord, I'm now going to turn to the evidence of colleagues, families, and friends of Mr. Timol, people who knew him best. Timol's mother never accepted the official finding that his son committed suicide. And certainly if one views the footage of her pain and anguish at the Truth and Reconciliation hearing on 30th April 1996, it was evident that she had never come to terms with this so-called suicide. Lord, we've heard from Esop Pahad, as well as Timol's brother Mohammed Timol. They both gave testimony on Timol's Islamic beliefs, which would have prevented him from committing suicide because Islam does not permit an adherent to take his own life. Moreover, Mohammed Timol, as well as Salim Esop, testified that Ahmed Timol loved life. He wouldn't have committed suicide. Pahad asserted that Timol was in love with his girlfriend, Ruth Longoni, and he was sad to leave London, and he had every intention of returning to her. Lord, these deeply personal testimonies suggest that Timol had no reason to commit suicide. In fact, he had every reason to live. My Lord, the evidence in respect of the South African Communist Party supposedly on suicide, the evidence we've placed before this court destroys the police version that it was party doctrine to commit suicide. I'm going to return shortly to the documents upon which the police relied. The evidence of Mr. Casserol's, as well as the other SACP members, was that it was never policy of the SACP to instruct or direct or suggest to their members that they should commit suicide. Ronnie Casserol's in particular dismissed the notion that Timol would have committed suicide to avoid a long prison sentence. And Casserol's, in his evidence, said that the Communist Party recruits actually saw lengthy prison sentences as a badge of honor. Some of the most respected and loved members of the ANC as well as the SACP were serving long sentences at the time. My Lord, turning to the question of Mr. X. Mr. X, the arrival of Mr. X and his pronouncement was apparently the cause for the prompt and sudden suicide of Mr. Timol. And as we well know, Mr. X marched in and pronounced that it had been positively established where Quinton, Martin, and Henry could be found, Quinton and Henry Jacobson and Martin Cohen. Now, my Lord, even on the police's own evidence, on their own version, this is rather curious, that suddenly they had discovered where these individuals were. My Lord, Lieutenant Colonel Willem van Wyk, only the day before, proudly boasted that notwithstanding Timol's reluctance to talk about these individuals and disclose their whereabouts, by then, and this is now Tuesday, they had already obtained their addresses. The reference is given. So, my Lord, the whereabouts of the Jacobson brothers and Mr. Cohen was no mystery. The Jacobson brothers operated a photographic studio in downtown Johannesburg in Pritchard Street, and they did so openly. There's the evidence of Aesop that he and Timol met them only once, and they ended up in the studio because Aesop shared an interest in photography. According to Aesop, the Jacobsons were not members of any political groups, and they were not involved in any organized political activity. So Timol only had a passing association with the Jacobsons. And my Lord, we have to submit that the police put up the Jacobson story as a pretense to explain the so-called sudden suicide, and it's a crude fabrication, my Lord. Indeed, if there was any political link between Jacobson and Timol, even a tenuous one, that would have been established at Jacobson's trial in April of 1972. And my Lord, there isn't a single mention, not a whisper, of Timol in Jacobson's detention file, and not a whisper of Timol in the judgment that led to Jacobson's acquittal. My Lord, Mr. X could not testify at the original inquest, apparently because of state security. We submit that the reason Mr. X could not testify was because he simply didn't exist. If Mr. X had existed, he could have been used as a secret witness in that inquest. It was fairly common practice through the 70s and 80s for courts in terrorism matters to hear the evidence of secret witnesses. And my Lord, we provide perhaps one of the better known examples coming from the Rivonia trial, where the state's star witness, one Bruno Mtolo, during the course of that trial was only known as Mr. X. He testified in secret. They could certainly have invoked the provisions of Section 156, sub 4 of the then Criminal Procedure Act 56 of 1955. And that particular section, my Lord, is in footnote 125, and it allows courts to hear evidence on a secret basis. My Lord, turning to the SACP publications, Lord, my learned friend, Mr. Pretorius, has already addressed you on these publications, so I'm not going to repeat what he has said.
Yes.
We would certainly endorse Mr. Pretorius's view of getting the names mixed up, and on that score, my Lord, I can tell you that the name was changed not behind closed doors, but was done with some fanfare back in 1953, as long back as 1953. And certainly those people in those circles, and not just those in the party, would have known that it was no longer the CSPA, but the SACP. And it is a glaring mistake that the authors of SACP documents certainly would not have made. My Lord, there's also evidence that typewriters were seized from Timol and others involved in the underground. There's also evidence that the reference to suicide in the two documents, Nkululeko Freedom 2 and the Frelimo Memorandum, happened to be at the very end of the documents, at the bottom of the pages. And the evidence of witnesses such as Ronnie Casserol's, Stephanie Kemp, Aesop Ahad said that would have made it considerably easier to adjust. My Lord, I think it's safe to conclude that the references to suicide in those two documents was a fabrication put up by the police in order to bolster the explanation of suicide. And my Lord, perhaps while I'm on that point, I should point out where we discovered Nkululeko Freedom number 2. It wasn't part of the record. You've already raised concern as to how it came before Magistrate de Villiers if it wasn't put up as an exhibit. And of course, if it wasn't put up as an exhibit, that meant the legal team were not in a position to interrogate its authenticity. My Lord, we discovered in Kulileko 2 by doing searches, and we found it in the Neil Agate inquest record. And my Lord will know that that is another famous inquest involving an alleged suicide. And we discovered that it was attached to the investigating officer's affidavit, one Captain Victor. And he put that up after doing a search of his files in the security branch. And my Lord, our submission is this document was the go-to document for suicides in both the Timol matter as well as the Agate matter. And on that score, my Lord, there is reference to Colonel van Rensburg, who dug up the Frelimo document. And my Lord, that is in the chronology on page 28 at entry 168. At the time he was a major, so Major Gert Janssen van Rensburg, he made out an affidavit in December of 71, saying that as far back as March of 1966, he raided a flat in Yeovil. And there he seized a number of books and documents, and lo and behold, there was the Frelimo memorandum, and lo and behold, it also encouraged suicide. And lo and behold, it happened to be sitting at the bottom of the last page. Lord, I wish to turn to the cover-up. And as I only have about 16 or 17 minutes left, I'm going to have to be brief. Yeah. My Lord, in our view, it can be safely concluded that the investigation into Timol's death constituted what can only be a brazen cover-up. Lord, in this regard, we would commend the evidence of both Mr. Frank Dutton, the family's investigator, as well as the evidence of George Bezos. They both set out in considerable detail why the investigation into this particular case was carried out not just in a sloppy manner, but in a manner designed not to reach the truth, in a manner designed to conceal that truth and protect the security branch officers concerned. Lord, we've heard the evidence of former branch officer Paul Erasmus. He says that the security branch routinely engaged in cover-ups to conceal the truth. He even spoke of a resident sweeper who they could call upon. He was their local expert who could come in and sweep away the evidence and ensure that the police would never have to face justice. Mr. Dutton, in his statement, set out over several pages, time doesn't permit me to take you through them, of what should have happened. And my Lord, none of it happened. And the question is, why didn't it happen? These include things such as inadequate statements being taken, no statements from eyewitnesses or bystanders. My Lord, one really has to ask, was it that difficult for the magistrate, for the prosecutor, for the investigating officer, to walk across the road from John Vorster Square, to knock on a few doors? What did you see? What did you hear on the 27th of October? My Lord, we did that some 45 odd years later, and we found some witnesses. One can only imagine what they would have unearthed if they had done such basic inquiry at the time. Clearly they didn't do it because they were not interested in coming up with the full truth. If that had been done, my Lord, I think the issue of timing would have been resolved by now. My Lord, much has been said about moving of the body and the total lack of a crime scene investigation, and Mr. Dutton deals with that in detail in his affidavit. Lord, what was the security branch covering up? It can only have been two things: the torture and the fact that there was no suicide. And if there wasn't a suicide, then it must have been murder. And my Lord, the main objective was to cover up the murder, because there are other ways of dealing with torture, and we've seen that from time to time. In fact, even in this particular case, where detainees are held and not released until their wounds have healed, and then they're leaned upon not to take legal action. And the case of Professor Nike is a case in point. He was only released some 4.5 months later, even though his questioning had stopped quite early on. And indeed, the case of Dr. Esop himself, that trial was also delayed for a similar period of time before he appeared in court publicly. Lord, we suggest that the Nike or Esop options were not available to the security branch because of the condition, the state of Timol at the time before the fall. And my Lord, we would suggest that the forensic medical evidence, as well as the circumstantial evidence from the other torture victims, suggest that Mr. Timol was likely at near death. He was in a dire physical state. And probably they wished to avoid the storm of censure, of criticism that would follow if another Esop, another Salim Esop took place within 24 hours, having to rush another comatose detainee to hospital. So, my Lord, they were covering up more than just the vicious torture of Timol. They were covering up his disposal, that is, his murder. My Lord, I'm going to deal briefly with the fact that no emergency services were summoned, and in this regard, we point out the compelling evidence of Professor Kenneth Boffard. At the time, my Lord, Professor Boffard said that even in those days, there was a fear amongst police officials that they shouldn't move critically injured persons, even those on highways, even when there was traffic rushing by, because they feared what might follow, the implications, perhaps the civil liability of what could follow if they moved critically injured persons. Professor Boffard pointed out what ought to have happened, and certainly what should have happened is that an ambulance should have been called immediately. That never happened. The moment they knew somebody had gone out the window, an ambulance should have been called. Instead, what happened? Mr. Timol was moved from the garden into the entrance hall and then up to the 9th floor. Professor Boffard had certain criticism of that conduct, my Lord. The point of impact was ideally situated. It fronted onto the road. The wall in those days, as we saw from the architectural evidence, was really low. One could simply step over. It was ideally placed for an ambulance to stop and for Mr. Timol to be taken away for emergency medical attention. And my Lord, there is evidence, of course, that Mr. Timol probably anyway. On that score, my Lord, and we haven't put it before this court, there are examples of individuals falling from higher than 10 floors who nonetheless survived. There are these reported cases, as rare as they might be. But we would conclude, my Lord, that failing to call the ambulance, the emergency services, can only be consistent with a desire on the part of the police to ensure his death and prevent a proper inquiry into the cause of his death. My Lord, I'm going to briefly deal with the probabilities. Mr. Pretorius has dealt with your responsibilities under the Inquest Act. We will not repeat these submissions. My Lord, in the light of the evidence before this court, we would submit that on the probabilities, Timol was murdered by the security police. He was brutally tortured. By the morning of Wednesday, 27 October 71, he was close to death, probably in a comatose state. To avoid another situation where a detainee, such as Salim Messap, is rushed to hospital from John Vorster Square within 24 hours, to avoid that situation, my Lord, we submit the suicide was constructed. Now, my Lord, sometime during 27 October 1971, and there is a dispute on the question of timing, all the non-police witnesses put the fall in the morning, and all the police witnesses put the fall in the afternoon. Lord, we've heard from Dr. Naidu and his evidence that it could have taken place either in the morning or in the afternoon. And my Lord, we would conclude that for purposes of these submissions, it didn't matter whether the fall took place in the morning or the afternoon. Our submissions still stand. We can only speculate as to what might have been the reason if it had taken place in the morning, my Lord. And that speculation would be that it would have given the security branch some breathing space, some time to put the fabricated version together, so that by late afternoon everybody was on the same page and they were ready to roll. My Lord, back to the probabilities. On the probabilities, my Lord, we suggest that Mr. Timol was either placed in a sitting position on the windowsill of room 1026 and pushed out, as per Mr. Mothle's scenario. Alternatively, he was pushed through that window, feet first, facing the building. As Mr. Mothle has testified, that would have placed him at 3 meters. Both those scenarios would have placed him at 3 meters in the dasal orientation. Alternatively, my Lord, he was thrown off the roof above room 1026, or he was pushed over from the low-lying parapet. My Lord, I should say that could have been an attractive option for the security branch, because they would clearly have been out of sight if it was simply a rollover, whereas the other options would have involved at least some seconds in which they would have been visible to passers-by down below. My Lord, as part of the cover-up, Rodriguez was brought in to fabricate a version and to explain away the conduct of the police. And this really was done, my Lord, to protect the from having to face withering cross-examination from the likes of George Bezos and Izzy Maisels. My Lord, we've heard about the conduct of General Bass. There's no need for me to rehash that. On the question of timing, my Lord, I would like to point out the point in time when Mr. Rodriguez was asked to change his version, when he was asked by General Bass as well as Captains Gloy and Van Niekerk to change the version to include, to add on something, and that was that he and Mr. Timol had a fight before the suicide took place. Well, Lord, one can really understand the reluctance of Mr. Rodriguez to take the further step, because it would have been an easy step for somebody to accuse Mr. Rodriguez, given that he had been fighting, apparently fighting, with Mr. Timol, that in a fit of rage Mr. Rodriguez assisted Mr. Timol out the building. So, my Lord, the reluctance of Mr. Rodriguez is quite understandable in our submission. But the timing is intriguing because, my Lord, we know that the Postmortem Report was signed by Dr. Skeepers. I believe that was on the 4th of November 1971. My Lord, that's on page 26 of the chronology at entry 151. My Lord, there's a possibility that the police got wind of what was in that report. They knew what was coming, namely that the PM report disclosed pre-fall injuries that somehow had to be explained. And, my Lord, it is our submission that that is why Mr. Rodriguez was then approached at some point, according to his evidence, before he made his statement on the 11th of November 1971. My Lord, I now turn to our recommendations. Lord, in the light of the evidence presented during these proceedings, we submit that a case has been made out for the reversal of the original inquest finding. My Lord, in respect of the police witnesses, we submit that Rodriguez played a role in Timol's death. My Lord, he should be investigated on charges of murder, accessory after the fact, and perjury. We say murder because of his role in the orchestration of Timol's death. We suggest an accessory after the fact because of his role in the cover-up, which persists, my Lord, to this very day, and as well as perjury for providing false evidence under oath before this inquest. We further recommend that Else and Sons be investigated on charges of perjury for providing false evidence under oath during these proceedings in relation to their denials of assault and abuse, and even witnessing such assault and abuse.
Apart from the murder charge, all other charges, if they have to stand, won't they be met with the prescription clause?
My Lord, in relation to what took place within the 20-year prescription limit, that is correct. But, my Lord, we would suggest that Mr. Rodriguez has persisted with the concoction, persisted with the cover-up to this day. My Lord, in our view, that makes him an accessory after the fact. And the same would apply, my Lord, to any falsehoods.
If he's charged with murder, accessory after the fact could be a competent verdict if murder is not proven.
That is correct, my Lord.
That might be the way to go around the limitation clause, the prescription clause. But the others, Else and Sons, if nothing links them to the murder of Timol as you submit on its own, that might be a defense raised.
Yes, my Lord, we're not suggesting that Else and Sons are connected to the murder of Timol. What we are suggesting is that they have perjured themselves before this inquest court.
Yes. Yes, before this court, yes.
Yes, my Lord.
Okay, proceed. We have a few minutes left.
Thanks, my Lord. I'm only a few minutes away, my Lord. We're approaching the conclusion. My Lord, we endorse the recommendations made by Mr. Imtiaz Kaji. We accept, my Lord, that strictly speaking, the recommendations in relation to memorialization and heritage and memory are strictly speaking not part of your legal mandate. Nonetheless, my Lord, we encourage you to make those recommendations in the hope that they will be picked up by responsible parties and authorities. My Lord, in conclusion, firstly, we would like to express our gratitude to those who assisted the Timol family in making this inquest happen. Special mention must go to our colleagues in the National Prosecuting Authority for their decision to reopen this inquest, as well as to Mr. Turi Pretorius and Ms. Shunam Singh for their tireless dedication to this matter. We'd also like to thank the South African Police Service, and in particular Brigadier Eleanor Groenewald. My Lord, we regret that we have drowned you in paperwork. Much of it comes from...
Certainly did that.
Much of it comes from General Eleanor Groenewald, and my Lord, you should hold her responsible. But we are certainly grateful that she went out of her way to assist us. My Lord, actually, I would like to single out Ms. Singh, because it was really her behind-the-scenes work that helped the mechanics of this inquest. For example, she ensured that we had easy and great access to John Vorster Square. My Lord, I'd like to thank Yasmin Suka and the Foundation for Human Rights for standing by the Timol family through all these decades when truth and justice seemed out of sight. My Lord, as counsel, we must pay tribute to our attorneys, Weber Wenzel attorneys and the Legal Resources Centre, Murray Hawthorne and Nasima Fakir and their respective teams. My Lord, my learned junior and I were mere conduits for their backbreaking work. And my Lord, we must thank the judiciary for setting aside valuable judicial resources so that this inquest could proceed in the manner that it did. Regrettably, my Lord, the issues that brought this inquest to this court have not disappeared. The practices of torture and assault are still prevalent in police custody. And my Lord, we've put up the IPED statistics, and we let those speak for themselves. Lord, while undergoing training in London by the South African Communist Party, Timol and the other recruits were given various books to read on how to deal with long prison sentences and how to cope with harsh interrogation. This was the evidence of Ronnie Casserol's. Amongst the books that were provided was one titled Notes from the Gallows by Julius Fukik. He wrote about his experiences at the hands of the Gestapo. He managed to smuggle out his story before he was executed. Lord Timol would have drawn great sustenance from this inspirational book. And we commend this honourable court to the 1948 review of the Fukik book by Howard Fast titled Hero's Diary. And my Lord, we've taken some license. We've adapted an extract from that review since we believe it applies with equal force to Mr. Timol, as well as others who've died in security detention. And I read, like thousands of other communists, Ahmed Timol died so that men and women may be free. In reliving Ahmed's life and struggle, we cannot write objectively. We can only take his hand, which is so strong in death, and thank him. He leaves the world to the living, and the fight he bequeaths us is a fight worth making. Press the hand of Ahmed and every comrade who did their duty and who endured his or her last battle. Ahmed and his comrades lived for happiness. For that they went to battle, for that they died. Let grief never be connected with their names. My Lord, while Ahmed's body was battered, his human spirit would have fought on all the way to the end. As the blows rained down on him, as he was repeatedly suffocated, as electrical currents raced through his body, as his life force slipped away, he would have looked to the future of his country, a future he had fought for and he would die for. Lord, the shining future Ahmed gazed upon in his final moments as our democratic South Africa, our constitutional order in which fundamental rights are guaranteed for all. He would have known that his approaching death would ultimately pave the way for a new South Africa with its enshrined freedoms, a South Africa in which an independent judiciary would wash away the lies and deception and expose the truth of his final days and hours. Ahmed would have wanted this, my lord, not for his own sake, but to ensure the eradication of torture and brutality in his beloved South Africa. Those are our submissions, my lord.
Thank you. We'll take an adjournment and come back at 2 o'clock for you.